Good afternoon, everyone. This is Heidi Meyers, immigration attorney. Today we're going to talk about Casa de Maryland versus Wolf. There was a preliminary injunction recently issued in the case, and it applies to work permits for asylum applicants. Now, the injunction only applies to members of the two organizations, Casa de Maryland and ASAP, Asylum Seekers Advocacy Project. So if you want to be covered by the preliminary injunction, you need to join either one of those organizations. So we're going to go over what the case is about and the new asylum work permit rules that it applies to. So the judge issued an order preventing USCIS, the Immigration Service, from implementing certain of the new work permit rules for asylum applicants if they are members of these two organizations. It is not a nationwide injunction. That's why you would have to join either one of them in order to be covered. So the first rule that the judge prohibited is the rule that rather than waiting 150 days after filing for asylum to apply for your work authorization, you would have to wait 365 days or a year before you're eligible to apply for work authorization. So members of Casa de Maryland and ASAP are able to use the old rule, which is you can apply for your work authorization after 150 days. As we all know, there are so many limitations on the 150 days where there are all kinds of, quote, clock stopping events. So many people actually aren't able to apply for asylum after 150 days. They actually have to wait a lot longer because of various clock stopping events, and then it's very difficult to get the clock started again. So those asylum applicants who now have to wait for 1 year before applying for work authorization also have to deal with all these other new rules about denying work authorization if any sort of delays occur in their case. So that's the first thing, is that if you're a member of Casa de Maryland or ASAP, the new rule about waiting for 1 year before you apply for work authorization does not apply to you. Second, the judge also prohibited the new rule that immigration can basically take as long as they like to adjudicate the first work permit application of an asylum applicant. So the prior rule was that USCIS, the Immigration Service, had to adjudicate work authorization applications for first-time applicants within 30 days. So you would wait the 150 days to apply for your work authorization, and then USCIS would have to adjudicate your application within 30 days. So theoretically, you would be able to get your work authorization after the 180th day, so in about 6 months. However, with the new rule, immigration can take as long as they like, and if you've checked current processing times, you can see that work authorizations are now taking 5 months, 6 months. So when you look at these two rules together, having to wait for 1 year before you can apply, and even after you apply, USCIS can just sort of sit on your work authorization for as long as they like. What, you're waiting a year and a half, maybe more, for your work permit? It's crazy. So the judge also prohibited immigration from getting out of that rule where they have to adjudicate your work authorization within 30 days. So if you're a member of these organizations, then your application, your initial work authorization, this doesn't apply to renewals, will be adjudicated within the 30 days. Now, another rule that the judge prohibited is that now immigration is saying with their new rule that if you entered the United States and did not apply for asylum within 1 year of entry, you are totally prohibited from getting any work authorization at all until after a judge or the asylum office determines that you qualify for an exception from the 1 year rule. So this would totally eliminate work authorization for many, many people, because many people applied more than 1 year later. Maybe circumstances changed in their home country, their personal circumstances changed. Things happen. So if you're a member of the class of these two organizations, then that new rule about not qualifying for work authorization if you made your application more than 1 year after entry does not apply to you. Next, let's see, the deemed complete provision. So, as you might know, USCIS is now using its mailroom as sort of judge, jury, and executioner. And so the mailroom loves to look at your application and see if there's any little box that wasn't filled in, or any teeny tiny little error or teeny tiny little omission as an excuse to just mail it back to you and not accept it. So we already had this problem. This has been going on for a while, that rather than accepting applications for filing, they're looking for the mailroom is looking for any little excuse to not accept it and mail it back to you. And this has caused a lot of people to miss the 1 year deadline, as you might know. So the judge also held in the preliminary injunction that if USCIS receives your asylum application and doesn't mail it back to you within 30 days, then it's still deemed complete. The other aspect is the biometrics fees. So you won't have to pay the additional $85 for biometrics if you are a member of the class. And the judge's order also prohibits USCIS from denying your work authorization application based on the exercise of discretion. So in the past, USCIS had to give you your work permit if you qualified. The new rule is, the individual officer can exercise their discretion, and even if you qualify, they don't have to give it to you. So the judge also prohibited that in the preliminary injunction. So basically, this is a preliminary injunction. The case is not yet complete. As I said, it only applies to members of these two organizations, Casa de Maryland and Asylum Seekers Advocacy Project. And so you would have to join, if you are an asylum applicant, you would have to join either of those two organizations to be covered by the judge's order. It is not a nationwide order. All right, folks, there are a lot more aspects to the new asylum rules. I will not cover them today, otherwise your head will be spinning. So that's it for today, folks. If you have an asylum case pending, and suppose you filed more than 1 year after your entry to the United States, or you're worried that you're going to have to wait a year to apply for your first work permit, etc., etc., I urge you to join one of these organizations. I'm not getting paid by anybody to tell you this. I'm just trying to give you some good information. My name is Heidi Meyers. I'm an immigration attorney. I also handle economic sanctions issues. I am located at 11 Broadway in Lower Manhattan, Suite 925, New York, New York, 10004. Our number is 212-791-4007 or 646 508-5225. And my email is heidimeyerslaw@gmail.com. I will put the information below in the notes. And thank you very much for watching this video. And please give me a like for the video and subscribe to my channel. All right, folks, nice to see you. I'll see you again soon. Bye-bye.